act was repealed, of these recruiters going into some LGBT offices in Utah or something to recruit. How was it, Alabama? Was that just a PR move? I mean, why not then go back to the people who had proven their courage, etc., to get them back in, rather than, make this move and go into some...
I think you answered your own question about whether it's a PR move. One of the reasons that, one of the questions that we continue to have to answer is, why is the government appealing in your case? Right? Why is the president appealing the judgment that finds that don't ask, don't tell is unconstitutional when he himself believes it weakens our military? And the answer is two things. The answer is politics and money, the same answers to every question when people ask about these things. So politically, the president wanted to take credit for the repeal of don't ask, don't tell, even though the legislative history is chock full of statements by people saying, we can't have some judge in California telling us what to do. We have to pass this law so we can control it. And then, of course, it's money. They don't want to pay back pay or benefits or full severance to people who were discharged under don't ask, don't tell. So that's a big part of what's going on. We also, yeah?
Sorry, I may have missed it. I'm just wondering what you think that vacating the order, the effect it'll have, if it has any effect.
It has a very significant effect. The Ninth Circuit order today also vacates the judgment that we had obtained. It vacates all of the district court's orders in the case. That means nothing the district court said could ever be used as precedent. As if it never happened. Congress has passed the repeal. That's still in place. The repeal is still there. So under this bill, you can walk in and apply, but there again is no law that says homosexuals can serve, and it can be changed at any time. There's no regulations about it. There's just internal policy memoranda that, of course, can be changed at any time, too. So who knows what's going to happen? Yeah.
So do you think there's an argument to be made in light of the fact that these discharged service members are still having issues around like their shoddy severance pay and their veteran benefits, for arguing that it actually is not moot despite the repeal?
Yes. There's an exception to the mootness doctrine we argue. It's called the collateral consequences doctrine. And it originates in habeas corpus cases. So if you are wrongfully convicted, you bring a habeas corpus claim, and you're released from prison, you can still maintain a lawsuit that challenges the validity of your conviction because the conviction has so many other collateral consequences. You can't vote and things like that. So we were arguing under that line of cases that the same thing applies here. People discharged under don't ask, don't tell were often discharged under less than honorable discharges and suffered collateral consequences in terms of benefits, back pay, and so forth. So we were arguing all that. And so far we haven't won. We will.
Can I ask a slightly then,
sure.
This might be a technical question about that exact point. So what was the result then you were hoping for, well, today or whenever?
Yeah, we were hoping that the court would say the case is not moot because of the public interest involved in the case and the importance of the issue, and that we were hoping they would find that would affirm on the merits. Okay? Failing that, we hoped that they might simply say the case is moot, but not vacate the judgment. Because then we'd still have the judgment to rely on in the future should a new Congress come and pass a new bill or a new president just issue an executive order banning gays in the military. So we were hoping for either of those two results. So here we are. Another thing that happened in the trial was we put on evidence about what happened in the militaries of foreign countries. And this was actually really interesting and important too. So after our country passed Don't Ask, Don't Tell, many other countries changed their laws and allowed open service. So those included England, Australia, Canada, Israel, and other countries. And so we introduced into evidence studies about what happened when those countries changed their rules. And the answer was nothing. It had no impact at all on the military readiness in those countries, and it was basically a non-event. People would come out to their friends or people they were close to, but what people feared, there's going to be a parade of 10,000 people wearing pink tutus in the military or something, of course never came to pass. So it was a non-event. The evidence that we put on also showed that our soldiers are fighting abroad all the time as part of coalitions of forces with other countries who can be gay. And our people are training with soldiers from other countries who are gay. Our people are learning from instructors in other countries in Canada and England who are gay, and in combat are often taking orders from coalition force leaders who might happen to be gay too. So that was another important piece of the evidence that we put on at the trial. But the most important part of this was the testimony of the former service members. I don't know how many of you have ever been to federal court, and you see the federal judge has interns and externs and law clerks. So when our experts testified, there would typically be one intern or law clerk observing and taking notes. When the former service members testified, all 6 of her interns, externs, and law clerks were there to watch. And so that told us how important that testimony was to the judge. One of the people you saw there was Stephen Bossler, and we put him on early in the trial because he was the sort of the poster boy for what the guy that Don't Ask, Don't Tell was supposed to protect. He was a farm boy from Nebraska who had never met a gay guy until he joined the Army. And so, of course, when he's out of boot camp, the first roommate he has is gay. And as he said in the video, it didn't matter to him. And so we thought it was important to put on a straight former service member too, along with the others, to testify that it didn't really make any difference. We also had a member of our client, Log Cabin Republican, who was in the service and is still in the service, because we have to have members who are impacted by Don't Ask, Don't Tell to have standing to sue. And he, of course, couldn't use his name because he would be discharged if he had testified at the trial. So we referred to him throughout the case as Lieutenant Colonel John Doe. We actually offered the government the possibility of exchanging his name, telling him the government his name if the government would agree not to discharge him. If we did that, and of course the government refused. So we had a person who's still in the military all this time. He was also not able to testify at the trial, so we had to use a written declaration from him in lieu of live testimony, which again was part of our First Amendment argument that he was deprived of the right to petition because of Don't Ask, Don't Tell. So all these more? Come. Law students with eager minds and lots of questions.
So now that the Ninth Circuit has vacated the judgment of the District Court, what is your next move?
I think I violated every law in San Francisco driving to your school this morning because I was speeding, driving in the wrong lanes, and talking on the phone. Not handheld in my rental car. And the client, I agreed that the next course of action is to seek rehearing on bond in front of the Ninth Circuit. The Ninth Circuit is a diverse group of people, I'll just say. We have a panel of the Ninth Circuit that ruled on motions in July that seemed to be favorably inclined to our position. The panel that heard the merits of the case is a different panel. And so, I would like to switch, but I can't. I'll just say the politics of the different judges on the circuit is all over the map. And so one of the people we drew, we had a chance to read the opinion that we got today, is still opposed to courts getting involved in military matters. And still wants to limit the impact of Lawrence. And basically his opinion says, and has been his view for a long time, that Don't Ask, Don't Tell was passed by Congress and the court shouldn't get involved at all. He dissented from, his view is not the majority view of the Ninth Circuit. The Ninth Circuit majority view is captured by the phrase, when talking about constitutional rights in the military, the well, we should defer to the military. Deference does not mean abdication. And so the courts will get involved in military matters when constitutional rights are involved. And again, we weren't asking our district court judge to decide or to instruct the military, how many bombs to drop, where to drop them, from what height to drop them, or any real military matters. We were talking about individual constitutional rights. Yeah.
Has there been any sort of like legislation action towards just allowing, just being we allow gay people to be present or anything like on that front?
No, the trend is the other way. In the new Congress, the trend is the other way.
Yeah.
So the House passed a bill to eliminate any funding for training about Don't Ask, Don't Tell repeal. Last month, the chairman of the House Armed Services Committee and the chairman of the subcommittee on Armed Forces wrote a letter to the Secretary of Defense asking him to delay the implementation of Don't Ask, Don't Tell repeal. So no, the trend is the other way.
Do you think that the sort of Prop 8 and how far it's going, that there could be some sort of, like, how do you reconcile the two?
As I said, the Ninth Circuit is a strange group. We'll see what they do in the Prop 8. If I just hope they have a panel that will leave it at that.
Our students finish discussing. Do you have any final parting comment?
No, thank you all very much for coming, and I'll stay for a few more minutes if those of you who don't have class want to talk some more. Okay, thanks very much.